All right, so by now you have gone through central booking. All right, you're waiting for your case to be arraigned. In the courthouse behind us on the first floor, you're going to see the arraignment parts. Now, these parts run from 9:30 a.m. to 1 a.m. every single day, 7 days a week, 365 days a year. Everybody always asks, what happens at the arraignment? Okay, does this mean that my loved one's case is dismissed? Do they go to jail? None of the above. All right, here's generally what happens. When a case is arraigned, the charges are either read aloud or we waive the reading, okay? And the prosecutor at that time will talk to the judge on the record about what the alleged facts of the case are, and then whether or not the people are asking for bail or whether they are consenting to their release. At the end of the people's presentation, the defense attorney, myself, gets a chance to talk to the judge and explain why, once the defense has the opportunity to speak to the judge on the record in open court, we discuss things like reasons why it is appropriate to release the suspect or the defendant without monetary bail. You can do it with supervised release if it is a more egregious offense. If it is a very run-of-the-mill where bail is not appropriate, the judge will almost exclusively release ROR, which means released on your own recognizance. So it doesn't cost you anything to get out. You're basically promising the court that you're going to appear on the day and time that the judge prescribes for the next court date. Now, the things that are important, well, remember, at that moment, the speedy trial clock begins to run. So the 30-30 clock starts on the day of arraignment, which if it's a misdemeanor, it's 90 days. If it's a felony, it's 180 days. So after the presentation to the judge from both the people and the defense, the judge will make a determination about bail or the lack thereof. And in this case, the arraignment will be concluded. Generally speaking, the criminal defendant will be released either ROR, supervised release, or if there's monetary bail, that will be input into the system. A short word about the 30-30 clock. All right, for misdemeanors, 30-30, just don't worry about 30-30. Just know that speedy trial time starts to run on a misdemeanor at the day of arraignment. So they have 90 days from that date. All right. On a felony, 30-30 starts the moment a suspect is arrested. So think of it like this. If a case was presented tomorrow, but the arrest happened today, the 30-30 clock will start today, Friday, and Saturday. Even if they don't get presented until Saturday, it's already been running since the day before. All right. Sometimes there's it's a confusing distinction to remember for felony cases versus misdemeanor. But remember, 90 days on a misdemeanor, 180 days on a felony. The next and probably the most important video for domestic violence cases, and we're going to talk about on the next video, and my partner Eli Crozier is going to join us on the next one, and we're going to talk about orders of protection, full orders of protection versus temporary orders of protection, modifications in family court. What does this mean for you if your loved one has an order of protection and they can't talk to you? We're going to talk about all of that in the next one. Click on the link, follow the next video.